advocates on screen. Good afternoon. Can I get appearances, please, starting with plaintiff?
Good afternoon, Your Honor. My name is Seva, Castleberry, and today I'm joined by Mr. Jacob Hervey. Good afternoon, Your Honor.
Afternoon.
Mr. Hervey will be dealing with our exhibits and our technology today.
Great.
And Your Honor, together we represent the estate of Miss Jessica Marks.
Thank you.
Appearances from the defense.
Please.
Good afternoon, Your Honor. On behalf of the defendant, Sonny's Bar, my name's Bennett Demsky. I'm joined by my co-counsel, Ms. Fatima Lawan.
Good afternoon, Your Honor.
Afternoon. Any housekeeping we need to take up before we turn to opening statements? We'll start with.
Yes, Your Honor, just a few things.
Go ahead.
First, Your Honor, we'd like to invoke Rule 603 and 615, the constructive swearing in of all witnesses and the constructive sequestration of all witnesses, barring party representatives. As the plaintiff, we have no party representative, Your Honor.
Defense.
Your Honor, yes, Your Honor. Ms. Mehta will be with us in trial today. She'll be representing her bar.
Great. That motion is granted with the exception of Ms. Mehta.
Yes, Your Honor. Now a few legal matters. Since this is a wrongful death suit and it's based on a unique California statute that punishes selling alcohol to minors, I'd like to draw your attention to the jury instructions made by the pretrial judge that lay out the issues in this case.
Okay.
Your Honor, here it says that under California law, a bar is liable for any injury or death caused by the selling, furnishing, or giving of alcohol to
Counsel,
any.
I'm going to stop you. Are you asking the court to do something?
Just to take note, Your Honor.
That's not necessary. What's next?
Yes, Your Honor. We'd also just like to note that obviously intoxicated is an objective, reasonable person standard.
All right. And this is for both sides. This isn't the time for argument. You can raise those if it becomes an argument during trial.
Yes, Your Honor. Understood.
What's next?
Lastly, we'd like to direct your attention to stipulation 14. It states that Jessica Marks was born on January 20th, 2000, meaning on March 24th, 2019, she was 19 years old.
Okay, that sounds like something that you may want to put into the record after we're on the record and the jury is present. Right now, this is just housekeeping. So if you'd like to read that into the record after your opening, you're welcome to.
Understood, Your Honor. Thank you. With that, the plaintiff is ready to proceed.
Mr. Demsky?
Just one housekeeping matter from the defense, Your Honor. When we share an exhibit to authenticate it with the witness for the first time, can we assume it's being seen constructively outside the sight of the jury?
No.
Yes, Your Honor.
Okay, so in other words, if you want to put something on screen, you need to admit it first or otherwise get leave of court. All the witnesses should have exhibit notebooks. If they don't, we'll correct that. But that way the jury doesn't see it unless and until it's in evidence.
Yes, Your Honor.
Great. Thank you, gentlemen. Anything else, Mr. Demsky?
Nope, we're ready to go.
Mr. Castleberry, the floor is yours. I'm going to have my video off so that way the camera gets some attention on you all unless there's an objection. Go ahead.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. They served, they saw, and they still didn't care. On March 24th, 2 years ago, a 19-year-old girl named Jessica Marks was driving on the highway. She was drunk, losing consciousness, slurring her words. She couldn't see straight. Suddenly, Jessica lost control of the wheel. The car went off a bridge and landed upside down at the bottom of a cliff. Jessica was dead. But members of the jury, today you're going to learn that Jessica's death could have been prevented. See, just hours before she died, Jessica walked in to the defendant's bar. She was underage, but they didn't care. Instead, they gave her drink after drink for hours. She started slurring her words, but the defendant gave her another glass of wine. She couldn't walk straight, but the defendant gave her pints of beer. She told the defendant she was going to drive home, but the defendant poured her another shot. And when the defendant let that 19-year-old girl stumble into her car, Jessica never had a chance. See, members of the jury, that's why Jessica's family is suing the defendant for wrongful death. See, the law says that when a bar knowingly sells alcohol to a drunk minor, and that minor dies because she was drunk, the bar is liable for her death. Now that means we have to prove it's more likely than not three things. First, that Jessica was obviously intoxicated, that the bar served her drinks anyways, and that the bar's action helped cause her death. And we'll meet that burden today by showing you that they served, they saw, and they still didn't care. So let's walk through those one by one. First, we'll show you how much alcohol the defendant served Jessica Marks. Today, you're going to hear from Jessica's best friend, Morgan Levin. Ms. Levin was with Jessica at that bar the whole night. She'll tell you that the defendant served Jessica an entire bottle of wine, multiple pints of beer, and shots. She'll tell you that Jessica was visibly drunk, but the bar kept serving her. Second, we'll show you that the defendant saw just how drunk Jessica got. You'll learn that the owner of the defendant bar, Sonny Mehta, saw Jessica lose her balance, heard Jessica slurring her words, and smelled the alcohol on Jessica's breath. In fact, the defendant saw Jessica fall down the stairs because of how much she had been drinking. The defendant kept giving her more. Finally, we'll show you that the defendant just didn't care about the danger they were putting Jessica in. You'll learn that late in the night, Jessica told the owner of the defendant bar that she was going to drive home. When the owner heard that, she didn't call Jessica a taxi or tell her to take an Uber or even take her keys. No, instead, she poured Jessica another shot and then let her stumble out the door to her car. They just didn't care. I want you to remember, we're here today because of Jessica Marks. As you sit throughout this trial, it might become easy to forget that Jessica was anything other than a college student who got too drunk one night. But you'll see that Jessica Marks was more than that. She was the daughter of a loving mother, a brilliant student with a bright future, and a good friend. When Jessica Marks died, she didn't get to graduate college. She didn't get to grow up, start a life of her own, or start a family. And members of the jury, we can't bring Jessica Marks back. But in a court of law, there's one thing we can do. We can give her family justice. We can do that by holding the people who caused her death accountable. That's why at the end of this trial, I'm going to come back up here and ask you to find Sonny's bar liable. Thank you.
Thank you, Mr. Castleberry. Mr. Demsky, you can proceed.
Yes, Your Honor. May it please the court, Mr. Castleberry. There was nothing to suspect, so there was nothing to stop. 10 times. That's how many times the owner of Sonny's bar, Sonny Mehta, walked up to Jessica Marks's table that night. You're going to hear that from our witness. You're going to hear that from theirs. 10 times Miss Mehta took their food and drinks, cleared their plates. 10 times Miss Mehta looked Jessica Marks in the eye. 10 times she walked back into that restaurant thinking Jessica Marks was absolutely fine. There was nothing to suspect, so there was nothing to stop. Members of the jury, no one today is going to tell you that Jessica Marks' death wasn't a tragedy. It was. No one today is going to tell you that Sonny's bar didn't serve Jessica Marks alcohol. They did. But when the plaintiff comes before you and accuses my client of being responsible for Miss Marks' death, we're going to show you a very simple explanation of why they're wrong. They believed Jessica Marks was okay. From what they saw, Jessica Marks was okay. There was nothing to suspect, so there was nothing to stop. And that's a problem for the plaintiff. Because in order to find Sonny's bar liable under the California Dram Act, the plaintiff needs to show you something called obvious intoxication. In other words, members of the jury, they need to prove by a preponderance of the evidence that it's more likely than not true that when they served Jessica Marks alcohol that night, she was so obviously intoxicated, so clearly impaired, so publicly inebriated that any reasonable person would have looked at her and said, that person is too drunk to keep drinking. That's a burden the plaintiff is not going to be able to meet because there are three very fundamental problems with their case, three questions that they won't be able to answer. First, what did the bartenders actually see? You're going to meet the owner of Sunny's Bar today, Miss Mehta. She's going to take that stand and walk you through the events of March 24th, 2019. She'll tell you how time and time and time again she went up to that table, clearing plates, taking orders. She'll tell you how she's trained to spot when people are intoxicated, but how she saw nothing of the sort. How there was nothing to suspect, so there was nothing to stop. Second, how much did Ms. Marks really have to drink? Because it's true, plaintiff counsel is going to show you a lot of drinks were on that table tonight, but he's not going to be able to prove who drank what, which drinks were consumed by Ms. Marks, and which drinks were consumed by her friend, Morgan Levin. In fact, members of the jury, we expect you'll see the only evidence they have is the word of that friend, their only witness in this case, Morgan Levin. And when you hear that, members of the jury, I expect you'll ask the last question yourself. Can we trust Morgan Levin? Because you're going to see today that the plaintiff's only witness is also their biggest problem. You're going to hear today that Morgan Levin was drunk that night. You're going to hear that Morgan Levin is testifying today after being threatened with a lawsuit by the plaintiff. You're going to hear that Morgan Levin's story is contradicted by multiple people who were at the bar that night. So when Ms. Levin takes the stand and testifies, members of the jury, ask yourselves, can we trust what she's saying? That's why at the end of today's trial, I'm going to come before you again. I'm going to remind you to ask those three questions in the deliberation room. And if you do, you'll see that there was nothing to suspect and there was nothing to stop. I'll ask you to find for the defense. Thank you.
Thank you, Mr. Demsky. We'll give Mr. Demsky a chance to go back to his computer. Mr. Castleberry, you can call your first witness.
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand. May we proceed?
Yes.
Good afternoon. Can you please introduce yourself to the jury?
Sure. My name is Morgan Levin.
Can you tell us how you know Jessica Marks?
Yeah, Jess was my best friend. We grew up together. We've known each other since we were toddlers.
Were you with Jessica on the night of March 24th, 2019?
Yes, I was. That was the night that Jess died.
That's all right. I need to ask you a few questions about that night.
Okay.
Where were you and Jessica that night?
Well, we were in LA. She came to visit me for spring break, and I took her to this bar. It's called Sunny's Rooftop Bar.
I want to try to keep track of what happened at that bar that night. Your Honor, permission to display a timeline on the screen?
Is it blank right now?
Yes, Your Honor.
That's fine.
And about what time did you and Jessica get to Sunny's?
About 9 p.m.
When did you leave?
We left around 11:45.
And between 9 and 11:45, did you see the defendant serve Jessica alcohol?
Yes, this woman, Sunny, who said that she was the owner of the bar, kept coming up to her table. She was serving us drinks that entire night for hours.
I want to take a closer look at how much alcohol the defendant served Jessica. Your Honor, permission to display Exhibit 14 on the screen?
Is that admitted?
No, Your Honor.
Do you need to admit it if you want to display it on screen?
Yes, Your Honor. Ms. Levin, do you have that exhibit booklet in front of you?
I do, yes.
Can you turn to Exhibit 14?
Yes, yes, I'm there.
Ma'am, what is Exhibit 14?
This is actually a picture I took that night. Those are some of the drinks that Sunny gave us.
Plaintiff moves 14 into evidence.
Defense?
No objection to 14, Your Honor.
14 is admitted. You can display.
Yes, Your Honor. Ma'am, when was this picture taken?
I don't remember the exact time, but it was in the middle of the night, so sometime between 9 and 11:45.
Can you tell us which of these drinks the defendant served to Jessica, to your knowledge?
Yeah, almost all of them were for her. The pint of beer, the glass of wine, and those 2 White Claws as well.
Mr. Harvey, can you put those on the timeline? Ms. Levin, did that photo show every drink the bar served Jessica that night, to your knowledge?
No, it didn't. Jess had another White Claw. She drank 3 total, and she also had some more of that wine. It was maybe 2 glasses.
Can we get that on the timeline as well, Mr. Harvey? All right, so remember, I'm seeing 1 pint of beer, 2 wine glasses, and 3 White Claws. How was Jessica acting around the time she was drinking?
Honestly, it was a little concerning. She was stumbling all over the place, slurring her words. Her eyes were all bloodshot too.
I want to talk about whether the defendant saw how the alcohol affected Jessica. Ma'am, when Jessica was slurring her words, was she around any employees?
Oh, I'm sure. The owner, Sunny, she kept coming up to our table and talking to us.
About how many times did Sunny come to your table when Jessica was acting like that?
Something like 8 or 9 times, maybe 10.
You also said that Jessica was stumbling. Do you know if any employees were around during that?
Yeah, around 10, Jess and we were walking down the stairs at the bar, and she was super off balance, and she tripped and she fell down nearly that entire flight. The owner, Sunny, was actually the one that caught her at the bottom.
Did you hear Sunny say anything?
Yeah, she looked at the bartender and said, "We might need to cut this one off."
Ma'am, after the bar's owner told the bartender that they might need to cut Jessica off, did they stop serving her drinks?
No, we were there for another hour and a half.
Okay, well, once the defendant served her more alcohol after she fell down the stairs, how was Jessica acting at that?
She got worse. She couldn't stand up straight. She couldn't string 2 sentences together. She was even yelling a lot, but none of what she was saying made any sense.
Ma'am, do you have any videos of Jessica from that time?
Yeah, I took a video.
Can you go to that video in your exhibit booklet?
Yes, I can. I'm there.
Ms. Levin, what is that video?
So it's the video that I took of how Jess was acting that night. I believe it's Exhibit 10.
Plaintiff moves 10 into evidence.
Any objections?
Without objection to the video.
Exhibit 10 is admitted.
Mr. Harvey, can you put that on the screen and play it for us?
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
What time did you record that video?
I believe it was around 11 p.m.
After you took that video, did Sunny say anything else to you about Jessica's drinking? Excuse me?
Yeah, Jess was trying to order another drink, and so Sunny came up. She pointed at Jessica, looked at me, and said, "I hope this one's not driving."
Ma'am, I have to ask. After the defendant said, "I hope this one's not driving," did she serve you all any more drinks?
Yeah. After that, she gave us a round of shots.
What happened at the end of the night when Jessica stopped drinking?
Well, I got our receipt, paid for everything, and then we went outside. I ordered an Uber. I didn't feel safe driving with Jess, but she drove, and I was in the Uber behind her.
What happened when Jessica drove away from the defendant's bar?
She made it a couple hundred feet to this bridge, and then her car, it swerved over the edge, and she fell.
Ms. Levin, I'm sorry to make you do this, but can you turn to Exhibit 18 in your booklet?
Yes, I'm there.
What is that?
That's a picture of Jessica's car. That's exactly what it looked like when it landed. That's the picture that the news used.
Plaintiff moves 18 into evidence.
Without objection.
18. Is that right, Mr. Castleberry?
Yes, Your Honor, 18.
That's admitted.
Mr. Hervey, can you get that on the timeline? Ma'am, do you remember what time this crash happened?
Yes, it was about 11:45.
Now, Ms. Levin, before I let you go, I need to ask you a few questions about whether the defendant cared about Jessica's safety. You said before that Jessica was slurring words and stumbling at her. At any point, did you see anyone working at the defendant's bar refuse to serve Jessica drinks?
No, I didn't.
At any point, did you see anyone working at the bar call Jessica a cab or an Uber?
No, I didn't.
And to your knowledge, what did the employees at the bar do as you were leaving that night?
Nothing. They just gave us those shots, and they let Jess walk out the door.
No further questions.
Cross-examination.
You may proceed.
Good afternoon, Ms. Levin. I want to begin by saying I'm very sorry for your loss.
Thank you.
Let's start by talking about how you came to be testifying in this case. Ma'am, the plaintiff is Jessica's mother. You know that, right?
Yeah, I do.
The plaintiff is the mother of your best friend.
Yeah.
After
That's right.
this accident happened, ma'am, the plaintiff, your best friend's mom, she started threatening to sue you, right?
She did. And frankly, I get it. I was with Jess. I should have stopped her. Someone should have stopped her from.
Ma'am, you know that getting sued in a case like this, it could cost you a lot of money, right?
Sure, I guess.
And the money aside, you didn't want to get sued by your best friend's mom.
My God, no, this entire thing is like a horror movie. I just feel so horrible. I never would have wanted that. No.
So sometime after the plaintiff was threatening to sue you, you sat down with her attorneys, right?
I did. Yes.
And when you sat down with Mr. Castleberry and his co-counsel, they didn't talk about suing you. They spoke about testifying in this case, right?
Yes, that's right. I talked with Jess's mom, apologized. And then I talked to her attorneys to see.
You spoke. Oh, I'm sorry, ma'am. I didn't know you weren't finished. Please continue.
Sorry, I was just gonna say, yes, we talked about this case, May 24th, all of that.
You spoke with Mr. Castleberry for 3 hours the day before your deposition?
I did. Honestly, this is really traumatizing, and I needed a few breaks.
You spoke with Mr. Castleberry before testifying today, right?
I did, yes.
Ma'am, as we sit here in court today, you're testifying on behalf of a plaintiff who threatened to sue you, right?
Yeah, I'm here for Jess.
That wasn't an answer to my question, ma'am. You're testifying for a plaintiff who threatened to sue you.
Yes, I am.
So let's talk about whether or not that threat is affecting your testimony. Because one thing you've claimed about that night is that you didn't have very much to drink, right?
No, I didn't.
Ma'am, you claim that at no point during that night were you drunk.
That's right, I wasn't.
That's not true, is it?
It is true, I wouldn't lie.
Do you know somebody named Kendall Reutemann, ma'am?
No, I'm sorry, I don't believe I do.
That's all right. Your Honor, at this time, we're going to read some portions of Kendall Reutemann's deposition into the record. That deposition is admissible under the hearsay exception rule 804. It's prior sworn testimony, so that's 804B1. And
Brief response, Your Honor?
Brief response. Do you have an objection?
Yes, Your Honor. I would like to see exactly what portion of the deposition they're planning to read onto the record, because while opposing counsel is right about the unavailable declarant exception, there actually may be some hearsay within hearsay issues in that testimony. So I'd like to see what portion is going to be reading on first.
Okay.
Sure. Your Honor, do we have permission to put those lines up?
Yes, we're now constructively outside the presence of the jury.
Yes, Your Honor. We're going to be reading from page 1, lines 13 to 16. And let me know when I should advance to the next set of lines.
Mr. Castleberry?
Sure. Yeah, next line is fine.
Do you have any, hold on, do you have any objections to this?
No objection to this page.
Okay.
Page 2, lines 16 and 17.
No objections.
And page 6, lines 6 through 13.
Yes, Your Honor. I believe there's some lack of foundation in this document, particularly her friend could barely walk in a straight line then, but I don't think anyone who drank as much as Jessica should get behind the wheel. Your Honor, we haven't already any foundation as to how Mr. Reutemann knows the information he's testifying to. Again, we can't cross-examine him, on the validity of his testimony. So, Your Honor, to bring this in would be improper.
May I respond?
Yeah, you can respond.
Yes, Your Honor. Rule 602 and Rule 701 don't call for the type of foundation Mr. Castleberry is asking for. We certainly see sufficient foundation in this document, or even in the lines we're going to read to the members of the jury from this document, that this person, Kendall Reutemann, was at the bar that night, that he recognized Jessica, and that he saw her that night. He's talking about his recollection of Jessica on that evening and what her friend was doing too.
Response, Your Honor?
Yeah, last word, go ahead.
Your Honor, we have a particular problem with the line, but I don't think anyone who drank as much as Jessica should get behind the wheel. We don't have Mr. Reutemann in court today. We can't cross-examine him on whether that's true and how he knows this. At this point, testimony is being laid onto the record, of which we have no foundation for. The jury has no foundation as to how Mr. Reutemann would know this, and even who Mr. Reutemann is. At this point, Your Honor, reading this part of the deposition onto the record would be improper and inadmissible.
Mr. Castleberry, you said we don't have the deponent in court. Wasn't your firm present at the deposition?
We were, Your Honor. That's right.
So you could have asked this witness whatever you wanted, and presumably both parties have had a chance to develop the witness's testimony. You're welcome to read in other portions if you think that they undermine it, but I don't think there's an issue with what Mr. Demsky is asking. So we're back on the record in front of the jury. The objection is overruled. Mr. Demsky, you can proceed with the portions we just discussed.
Yes, Your Honor. And Your Honor, Ms. Lowan is going to be reading the answers in the deposition.
Okay.
Page 1, lines 13 to 16. We're here to talk about an incident that occurred on March 24th, 2019. Where were you around 9 p.m. that night?
Sonny's, watching the end of the Lakers-Kings game.
Page 2, lines 16 to 17. Showing you Exhibit 2. Did you see this woman that night?
Yeah, and I saw her on the news the next day.
And now I apologize. Now page 6, lines 6 through 13. Were you concerned about Jessica getting behind the wheel?
She was in better shape than her friend. Her friend could barely walk in a straight line to the Uber. But I don't think anyone who drank as much as Jessica should get behind the wheel.
How was she walking?
Fine, I guess. I don't really remember. I just remember her friend was wobbling like she'd been in the ring with a boxer.
Thank you, Miss Lowen. You can take that down. Ms. Levin, and this question's to you now. You were the friend that was with Jessica Marks that night, right?
I was with Jessica that night. I can't speak to what I think you said his name was Kendall was talking about, though, or what he saw.
Ma'am, I'll ask you this. Were there any other friends sitting at the table with you and Jessica that night?
No, it was just the two of us.
So to be clear, when this witness says that Jessica was in better shape than her friend, you deny that that's talking about you, don't you?
No, not at all. I'm just saying I don't know. I would assume that he's talking about me, but I couldn't tell you for sure.
Ma'am, when this witness says that the friend could barely walk in a straight line, you're telling us that's not true about you?
If he was saying that about me, no. Frankly, I know my limits and I know what I can and can't drink to make sure that I am in a good enough shape to make it home that night.
When he
And that
says,
night I was.
I'm sorry, when the witness says that the friend was wobbling like they'd been in a ring with a boxer, you're telling us that's not true about yourself, right?
That's right. I was sober enough to make it home that night.
So we've talked about what that witness saw. I want to talk about how much Jessica really had to drink that night. One of the big claims you made on direct examination was that Jessica had quite a lot to drink, right?
Yes, she did.
You showed us pictures, didn't you?
I did.
But I want to be really clear for the members of the jury. This photo you showed us, it doesn't tell us who drank what, does it?
No, it doesn't.
Just shows us drinks on a table.
That's right.
And the truth is, ma'am, when you tell us Jessica had all these drinks on March 24th, 2019, well, that hasn't always been your story, has it?
What do you mean?
Ma'am, the night that this crash happened, you were interviewed by the police, weren't you?
Yes, I was.
And you spoke to the police right after this crash happened. Isn't that true?
I believe I did.
You spoke to the police long before you were threatened with a lawsuit by this plaintiff, right?
I believe so, yes.
Ma'am, the night this all happened, you didn't tell the police that Jessica was stumbling around drunk, did you?
No, I don't think so.
You didn't tell the police that Jessica had way too much to drink?
No, I didn't. I didn't know it was important.
Ms. Levin, what you told the police before this lawsuit was that Jessica had only a few drinks that whole night.
Yes, I think that's what I said.
You told the police she only had 3 drinks in the entire time you were at the bar.
I think I said she had a few, yes.
Ma'am, 3, right?
I believe so. I think I said about 3.
Thank you, ma'am. Nothing further.
Anything further?
Redirect, Your Honor.
Go ahead.
Ms. Levin, Mr. Demsky just asked you a whole bunch of questions about the number of drinks that you had that night and whether you were drunk. Ms. Levin, how many drinks did you have at Sunny's?
I only had 3. I had a beer, a couple sips of wine, and a shot. Really wasn't enough to make me impaired in any way.
Nothing further, Your Honor.
No recross.
Thank you very much, Ms. Levin. You are excused.
Your Honor, with that, the plaintiff rests its case in chief.
Okay. Mr. Demsky, you prepared to call a witness?
We are, Your Honor. Defense calls Sunny Mehta to the stand. Permission to proceed?
Yes.
Good afternoon. Can you please introduce yourself to the members of the jury?
Hi, I'm Sunny Mehta.
What do you do for a living, ma'am?
I own a rooftop bar here in LA. It's called Sunny's Rooftop Bar. I bought the property back in 2017 and I've been running it ever since.
Ma'am, do you know why you're here in court?
Yes. They're saying that we kept serving a woman that came into my bar, Jessica Marks, even though she was too drunk. They're saying it killed her.
Ma'am, I want to get this out of the way right at the start. At any point that you served Jessica Marks that night, did she seem drunk to you?
Absolutely not. I run my business with integrity. I care about my customers. So I try to do everything within my power to keep them safe. And that's exactly what I did when Jessica came into my bar that night.
Objection, Your Honor, 404 improper character evidence.
How so?
I'm sorry, Your Honor.
How so?
Yes, Your Honor, Ms. Metha is now testifying to her own character, that she takes care of people, that she always checks on people, is in fact a good barkeeper, and that she checks on her customers. Your Honor, they're using this for propensity purposes to show that because she has this character trait to do that, that in fact she did that on the night in question.
Mr. Demsky?
Yes, Your Honor. She's the defendant in this lawsuit. She's allowed to say she didn't do it. She's allowed to say this isn't something she would have ever done.
Well, I think Mr. Castleberry is saying she's allowed to say the first part, but not the second part. Why isn't the second part of your explanation that she would never do this and hasn't done this? Why isn't that improper character?
Because, Your Honor, we believe the jury can take Ms. Mehta at her word. We're happy with a limiting instruction that they shouldn't take this to mean that she's never done it in the past, so she wouldn't do it in this case. She's just saying that she didn't do it in this case and that she doesn't overserve her customers.
Response, Your Honor?
Go ahead.
Your Honor, we'd like more than a limiting instruction. Ms. Metha is clearly testifying to improper character evidence. It would be wrong for the jury to hear it. The limiting instruction is not enough, Your Honor. This testimony is not admissible.
Mr. Castleberry, why should I not find that you opened the door to this by talking about how careless the defendant is?
Yes, Your Honor, because she's specifically testifying to her past character. In fact, she has this trait in the past to care for her customers, that this is the thing she always does. The door that we opened was to her specific negligence on the night in question, whether the people at her bar didn't call her an Uber, didn't give her a cab, didn't take her keys. Ms. Metha is testifying to character evidence. What we opened the door to was the day in question.
Yeah, so here's where the court comes down on this. This is not a negligence case. I didn't interrupt your opening statement because if there's no objection, I'm not going to rule on it, but the plaintiff is trying this so far as a negligence action, and it's a dram shop action. So the only question is whether or not a minor who was visibly intoxicated was served. So I think that you open the door to making the amount that this witness cares an issue. And I'm not going to let it go too far. I don't want to hear more about it, but I'm going to overrule the objection and I'm going to let the defense respond.
Understood, Your Honor. Yes.
Yes, Your Honor. Ms. Mehta, were you finished with your answer?
I was, yes.
Have you been in court with us today?
I have.
We heard Ms. Levin say that Jessica ran into you falling down the stairs. Did that happen?
No, it didn't.
We heard Ms. Levin say that you said you might need to cut Jessica off. How about that? Is that true?
No, again, I didn't say anything like that.
So, ma'am, I want to walk through the events of March 24th, 2019, starting at the beginning. When did Jessica Marks first come into your bar?
It was around 9 p.m. She walked in and we seated her.
Your Honor, permission to put up a timeline and place that on it?
Yes, you may.
Ma'am, was Ms. Marks alone when she came in?
No, she had a friend with her. I went over to take their orders and the friend introduced herself as Morgan.
Ma'am, do you have exhibits 8 and 9 in your exhibit booklet in front of you?
I do, yes.
Can you tell us what those are?
Yeah, exhibit 8 is a picture of the rooftop bar, and exhibit 9 is our indoor seating below the rooftop bar. It's also where our drinks are made.
Do those look to be fair and accurate?
They do, yes.
We offer 8 and 9, Your Honor.
No objection, Your Honor.
8 and 9 are admitted.
Permission to publish?
Go ahead.
All right, let's put those up. Ma'am, can you tell us where in these two pictures Ms. Marks and Ms. Levin were sitting?
Sure, they were sitting in the chair in the lower right of exhibit 8.
Let the record reflect I'm marking that location where they were sitting with a red circle. Just for context, Miss Maida, can you tell us how many other people were sitting on the rooftop bar that night?
Throughout the night, maybe 14, 15 other people, something like that.
So there are 14, 15 other people up there that night. Were you giving Jessica and Morgan your full attention throughout the night?
Definitely not. It would have been impossible. I mean, I went on to check on them every so often, but I certainly wasn't watching them the entire night, no.
Were you even on the rooftop for the entire night?
No, like I said, we mix the drinks inside and then bring them up to the guests. So if I'm going up to the rooftop, it's only just to get orders and deliver orders.
Ma'am, I want to talk now about what you saw when you went up to Jessica and Morgan. Let me ask you, can you tell when somebody's drunk?
Typically, yes. As a business that sells alcohol here in California, my staff and I have to complete a state-approved course that teaches us how to recognize when somebody might be intoxicated.
How do you judge if someone's intoxicated?
There are a bunch of signs that they give us in the course and that I just know from common sense. So some of them might be red and watery eyes, slurred speech, stumbling, talking loudly, things of that nature.
Ma'am, when you saw Miss Marks at 9 o'clock, when she first came into your bar, did she have any of those signs you just spoke about?
Absolutely not. I mean, I wouldn't have started serving her if she did.
Ma'am, how many times over the course of the evening did you interact with Jessica Marks?
Between taking their orders, bringing food and drinks, collecting their stuff, say maybe about 10 times I interacted with them.
Your Honor, permission to put up a demonstrative. It'll have a visual representation of the testimony we're about to elicit from the witness.
As long as the visual representation comes after the testimony, that's fine.
Yes, Your Honor. Ma'am, in the 10 times that you saw Jessica Marks, were her eyes red or watery?
No,
In the 10 times you saw Jessica Marks, was she slurring her words?
again, no.
Did she ever seem to lose coordination, stumble?
No, not that I saw.
Let the record reflect that we're placing 3 X's next to each one of those characteristics to indicate that this witness did not see Jessica Marks display any of those things. Ma'am, with all of that considered, did you have any reason to believe that Ms. Marks was intoxicated during any of the 10 times you went up to her?
I had no reason to believe that at all. No.
So we've talked about what you saw of Ms. Marks that night. I want to turn our attention now to her friend, Ms. Levin. Did Ms. Levin have red or watery eyes when you saw her?
Yeah, I noticed her eyes were definitely a little bloodshot. Yeah.
Was Ms. Levin slurring her words?
Yes, a little bit.
Did you see Ms. Levin stumble?
Yes, on her way out, I definitely saw her stumble.
Let the record reflect we've placed 3 green check marks next to each one of these to indicate that the witness did see Ms. Levin displaying those characteristics. Ma'am, I want to talk now about what happened when Ms. Marks and Ms. Levin left your bar. Did you ever speak to them?
Yeah, I spoke to them at around 11:45 when they were on their way out.
Let's put that on our timeline. Ma'am, does this timeline accurately reflect your testimony in court today?
Yes, it does.
So when they were leaving the bar at 11:45, did you speak to them?
Yeah, I asked them who would be driving.
Why?
I just wanted to check because I was a little worried about Morgan after I saw her stumbling out, and I wanted them to be safe.
Did they tell you who'd be driving?
Yeah, Morgan said that Jessica planned to drive, not her. And Jessica didn't seem drunk to me, so I didn't pry any further.
Miss Maida, when Jessica Marks walked out of your bar, did you have any reason to believe that she would get in a car crash?
None at all. I've been a bartender for years. I've seen thousands of drunk bar goers. And look, if I don't think someone is good to drive, I don't let them do it. But from everything I could tell, Jessica seemed absolutely fine to me.
Thank you, ma'am. Nothing further.
You can
Cross, Your
proceed.
Honor.
Go ahead.
Hello, Ms. Mehta.
Hi.
Ma'am, you said on direct examination something interesting I want to ask you about. You said that Miss Levin was the one with red eyes, the one slurring her words, and the one stumbling. Do I have that right?
From what I saw, yes.
I want to be clear about how much you actually saw Morgan drink. Ms. Mehta, do you have your exhibit booklet in front of you?
I can pull it up, yeah.
Can you turn to exhibit 17?
Sure.
Man, that's the receipt from that night with Jessica and Morgan on it, isn't it?
Yes,
Looks fair and accurate?
it does.
Plaintiff moves 17 into evidence.
Objection to hearsay. May I be heard?
Yes.
So, Your Honor, we haven't heard any foundation as to how this receipt is admissible. It's an out-of-court statement being offered for the truth. We asked if they want to bring it in, that they just lay some foundation as to how it is a record of regularly conducted business activity.
Response, Your Honor?
Go ahead.
Your Honor, we're actually not even planning on admitting this through the 8036 exception. It's actually just a statement by a party opponent. Your Honor, the defendant is Sonny's Bar. This receipt was produced by Sonny's Bar. It says Sonny's Bar right on the top.
Overruled. It's admitted.
Yes, Your Honor.
Mr. Hervey, can we get that on screen? Ms. Mehta, this is Jessica and Morgan's receipt from that night, right?
That's correct.
Now, you talked a lot about Morgan maybe being drunk, but you don't actually remember which of the drinks on this list Morgan ordered, do you?
No, they ordered them together. I just took it to their general table.
So that's a no. You don't remember which of the drinks on this list Morgan ordered.
No, I don't.
You also don't remember which of the drinks on this list Morgan drank.
No, I don't.
You don't remember seeing Morgan finish any of the drinks on this list?
Also, no.
In fact, ma'am, you would actually say you don't remember how much alcohol Morgan drank that night. Yes or no?
I don't know.
Ms. Mehta, still, you're claiming today that you didn't believe Jessica was drunk that night. But I want to talk about just how many drinks you served her. Mr. Hervey, can we get that timeline up? Ms. Mehta, you heard Morgan Levin testify today, right?
I did.
You heard Morgan Levin testify that you served Jessica wine, seltzer, and beer.
That's correct.
Ms. Mehta, like you said earlier, you were actually the one who took the orders for all those drinks.
I was, yes.
You were the one who cleared their table multiple times.
Yes,
You were the one who brought all those drinks to their table.
that's right.
But despite bringing all those drinks to their table, you're claiming Jessica wasn't acting drunk. I want to show you something. Mr. Hervey, can we get that video on screen, exhibit 10? And Your Honor, this has been pre-admitted.
You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Mehta, you heard Morgan testify that this video was taken around 11 p.m., right?
I believe that's what she said.
Around 11 p.m.? You didn't cut Jessica off of drinking, did you?
No, I never saw her act like this, so I didn't.
Around 11 p.m., you didn't think, well, Jessica, she's too drunk. It isn't safe to give her more alcohol.
No, again, I never saw her like this.
What you did do was you asked Jessica and Morgan about who was driving home.
That's right.
Ma'am, that's when Jessica said, I'm going to drive home. Do I have that right?
Yeah, she did.
All right, I want to get something straight. When Jessica told you that she was going to drive home, you didn't say you can't do that.
No, she seemed fine to drive, so I let her.
You didn't call her an Uber?
No.
Didn't take her keys away?
No.
No, instead, You served them a round of shots.
A little bit before, she seemed fine, yeah.
So you sold her a shot and then you let her walk out the door. Do I have that right?
Right, a little bit after, I gauged her and she seemed fine to drive.
Ma'am, you're saying she seemed fine to drive. You're aware that minutes after you let her walk out that door with car keys, she drove off the side of a bridge.
I am.
You're saying she seemed fine to drive minutes after you let her walk out that door. She died. Do I have that right?
That's right.
Now, there's one last thing. You said on direct that you had no reason to believe she would get in a car crash. Your Honor, we're now displaying Exhibit 22. This has been pre-admitted before trial. Permission to read a portion of Exhibit 22.
Go ahead.
Exhibit 22 states that blood drawn at the scene of accident contains 0.16 grams per 100 milliliter of blood, BAC. Thank you, ma'am. Nothing further.
Mr. Demsky?
No redirect, Your Honor. I just asked that Ms. Mehta be allowed to step down.
Thank you very much, Ms. Mehta.
With that, we close our case. We're ready for closings.
Great. Can I get a time check from the bailiffs, please? Or the second chairs?
Mr. Herbert?
Yes, Your Honor, I have the plaintiff has used 18 minutes and 55 seconds of their 30 minutes. And the defense has used 20 minutes and 45 seconds of their 30 minutes.
And does our other timekeeper agree?
Yes, we agree with that.
Terrific. We'll turn to closing arguments. Whenever you're ready, you can proceed, Mr. Castleberry, and you don't need to reserve any time. It's automatically reserved.
Thank you, Your Honor. Your Honor, opposing counsel, members of the jury may please the court. They served, they saw, and they still didn't care. Members of the jury, I know it's not easy to remember everything that's been said on a 2-hour Zoom call. But if there's one moment I want you to remember from today's trial, it's this. On cross-examination, the owner of the defendant bar admitted that Jessica told her point blank, "I'm going to drive home." Members of the jury, her BAC was at a 0.16 when she said that. In that moment, the defendant could have stopped all of this. In that moment, the defendant could have said, "No, you're not." She could have taken Jessica's keys. She could have called her a taxi. She could have told her to stop drinking. In that moment, the defendant could have prevented Jessica's death. The defendant didn't do any of those things. No, instead, she looked back at the 19-year-old girl she had been serving drinks all night, and she gave her another round of shots. And she watched as Jessica took her keys, stumbled out the door, and peeled out of the parking lot. Minutes later, Jessica Marks was dead. You see, members of the jury, that's why Jessica's family brought this lawsuit. See, today we had the burden to prove to you, by preponderance of the evidence, that the defendant wrongfully caused the death of Jessica Marks by serving her alcohol, even though she was obviously intoxicated. And members of the jury, we've met that burden. We did that by showing you that the defendant served, saw, and still didn't care. So let's go through those one by one. First, the alcohol they served. Members of the jury, you learned today that they gave her beer. They gave her liquor. They gave her 3 cans of White Claw, 2 glasses of wine, and a round of shots. For 3 hours, the defendant did nothing but serve a 19-year-old girl drinks. That's true. Jessica chose to drink all on her own. She's the one who chose to drive. No one here is going to tell you that she made safe choices that night. But under the laws in this state, she was just a kid. And the law tells us that when a kid ends up drunk at a bar, the adults working there have a legal responsibility to do the bare minimum to prevent tragedy. But as you watch this list of drinks get longer and longer, you know the defendant didn't do that. Next, you'll learn that they saw exactly how drunk Jessica was. You saw that video. You heard that the owner of Sonny's bar saw Jessica fall down the stairs. She said, "Whoa, we might need to cut this one off." She said, "I hope this one's not driving." The defendant's own words make it clear. She saw what they were doing. But still, you learn how the defendant just didn't care about the danger they put Jessica in. When Jessica started slurring her words, they gave her more wine. When she fell down the stairs, they gave her more beer. When she said, "I'm going to drive," they gave her more shots. And we all know what happened next. That 19-year-old girl got in her car, drove onto a bridge, lost control of the wheel, and she fell. Members of the jury, we showed you how much alcohol they served Jessica, how they saw Jessica get drunk, how they still didn't care about her safety. They served, they saw, they still didn't care. Members of the jury, that's wrongful death. But still, Mr. Demsky wants you to believe that the defendant just had no idea Jessica was drunk. The bar owner really got up here and told you that she had no reason to believe Jessica wasn't perfectly sober. Isn't that convenient? Really, all the hard evidence shows that Jessica was visibly drunk and anyone at the bar would have seen. Mr. Hervey, can we get that timeline up? Morgan Levin saw it. We got pictures. We even have it on video. The defense wants to make it seem like this is just Morgan's word versus Sonny's, but it isn't. It's the word of a defendant who has everything to lose against eyewitness testimony, photographic evidence, and a video that makes clear exactly what happened that night. But besides, the law says that the defendant is liable if a reasonable person would have known Jessica was drunk. So it doesn't matter if all the employees at the bar covered their eyes and closed their ears and pretended not to notice the drunk teenager right in front of them. If they didn't see it, then they should have. And the law makes them liable either way. The members of the jury, it's been almost 2 years that the Marks family has been searching for answers. Almost 2 years they've been fighting for justice. There's nothing any of us can do that will bring Jessica Marks back. We know that. There's one thing you can do. You can make sure that next year is just a little bit easier for Jessica's family. You can hold the defendant accountable for their actions. You can find the defendant liable. Thank you.
Thank you, counsel. Mr. Demsky, you can proceed.
Yes, Your Honor. Mr. Castleberry, may it please the court. When tragedy strikes, as human beings, we have a tendency, an impulse to want somebody held accountable. And when a young girl with a bright future ends up dead in a car wreck at the bottom of a ravine, it's difficult to grapple with a simple truth. That sometimes accidents happen, and they happen for no good reason at all. It's easy to jump to conclusions. It's easy to find a story, to file a lawsuit, to choose the most convenient villain. And in this case, that's exactly what the plaintiff has done. Sunny Mehta's bar is not responsible for Jessica Marks's death. They didn't suspect that she was too drunk to keep drinking, so there was no reason to stop serving her. It's as simple as that. Members of the jury, that poses a problem for the plaintiff. Because in order for you to find Sunny's bar liable under the California Dram Shop Act, the plaintiff didn't have to prove that Jessica Marks was a minor, or just that she was served drinks that night, or even that she was served too many drinks that night. No, they had to prove that Sunny's bar staff served her drinks even though she was obviously intoxicated. Where we disagree with the plaintiff, what they've failed to prove to you today by the weight of the evidence is that crucial element, that Sunny's bar saw signs of obvious intoxication, that they should have known to stop serving. So to talk about how the plaintiff has failed to meet that burden, I want to return to the 3 questions I asked you at the start of today's trial. What did the bartenders actually see? How much did Jessica Marks really drink? And can we trust Morgan Levin? Let's start with the first one. What did the bartenders actually see? 10 times. 10 times Miss Mehta walked up to that table. That's what they're witnessing. 10 times Sunny Mehta spoke to them, looked them in the eye, and didn't see anything. No bloodshot red eyes. No slurred speech, certainly no stumbling down. A girl who had been drinking, yes, but not a girl who was drunk. Today, Miss Mehta came to the stand. She looked you in the eye. She told you that's exactly what happened. Members of the jury, that's testimony that was corroborated by someone else who was at the bar that night. We won't just ask you to take the defendant's word for it. We brought you deposition testimony from Kendall Whiteman, another patron who was there. He told you that Jessica Marks wasn't that drunk, that he wasn't worried about her. And that brings us to the second question. How much did Ms. Marks really had to drink? Members of the jury, Mr. Castleberry showed you that receipt. Let's look at that receipt. The plaintiff has come up here and they've asked you to take it for granted. Like the mere fact that there are drinks listed means that Jessica Marks must have consumed them. But we know from the testimony of Sunny Mehta that isn't true. Morgan Levin consumed quite a lot of alcohol that night. And again, that testimony is corroborated by Kendall Whiteman. Mr. Whiteman doesn't work for the defense. He doesn't work for the plaintiff. He was a guy at the bar. He has no dog in this fight. And he told you without bias, without interest, without motive in today's case that it was Miss Levin, their witness, who was in way worse shape than Jessica Marks. So what evidence did they bring? Mr. Castleberry says it's a 2-hour call. It's hard to remember what happened. Folks, this call's been barely 1 hour, and what's easy to remember is that they only called one witness to the stand. The testimony of Morgan Levin, that's what they've staked their case on. We'll talk about why we can't trust Morgan Levin in just a second, members of the jury, but the only hard evidence they showed you to prove that Jessica Marks had consumed a lot of alcohol was that video, Exhibit 10. But there's a fact about that video the plaintiff doesn't want you to think of. Jessica was in front of a camera. She was making a video to post on social media about her fun night out. Of course, she's going to act more intoxicated in that video. Of course, she's going to act differently in that video than how she acts in front of the bartender. And Miss Mehta told you that she never saw Jessica acting that way on March 24th, 2019. That brings us to the third question. Can we trust Morgan Levin? We can't, members of the jury. And it isn't just because Morgan Levin told you today she feels responsible for this tragedy. It isn't just because she's got motive not to tell the truth. It isn't just because she was threatened with a lawsuit by Mr. Castleberry. It isn't just that she was threatened with a lawsuit by the plaintiff in this case. It isn't just the fact that she spoke with Mr. Castleberry before she was deposed, or that she spoke with Mr. Castleberry before she testified today. It's the fact that she was drunk that night. It's the fact that we heard testimony from Ms. Metza and Mr. Reutemann that she had drinks, that she was practically falling over, that she had all the signs of intoxication that they were talking about. And we know, members of the jury, because she couldn't keep her story straight. First, she comes into court and she says one thing. Then we learn the night of the accident, before she was threatened with a lawsuit, before she came to court and testified, she told the police that Jessica Marks had only had 3 drinks that night. Folks, when the plaintiff asks you to take Ms. Levin at her word today, when they stake the fate of their entire lawsuit on the testimony of a single witness who admitted herself that she was almost sued by the same people who are asking you to trust her right now, I want you to remember, we can't believe a single word out of Morgan Levin's mouth. But I know. A 19-year-old girl is dead, and Mr. Castleberry and the plaintiff, they want someone to blame for that. You want someone to blame for that. I want someone to blame for that. Here's the problem. Sometimes we get so caught up in blame, in who wins, who loses, that we lose sight of why we're here. Because it isn't to blame, and it isn't to win. And it isn't to guess, it's to help you find the truth. And the truth is that sometimes there are cases like these. Cases where nobody wins. Cases where no one's to blame. Make no mistake, members of the jury, if you find the wrong person liable for Jessica Marks' death, everybody loses. There was nothing to suspect. So there was nothing to stop. Find Sonny's bar not liable. Thank you.
Thank you, Mr. Demsky. How much time remains for Mr. Castleberry's rebuttal?
Mr. Herbert?
I have it at 4 minutes and 30 seconds remaining for rebuttal.
You may proceed.
Members of the jury, I want you to think closely about what the defense wants you to believe. The defense wants you to believe a story that makes absolutely no sense. They're telling you that actually Morgan Levin was the one who was drinking that night. Morgan Levin was the drunk one, and that Morgan Levin, just misremembered the entire night, or that actually she's lying to you because of a lawsuit. Members of the jury, their own witness's testimony shows that that story doesn't make any sense. Think about it. Sonny Mehta served every drink at Morgan and Jessica's table, cleared that table, and came back 10 times throughout that night. If there's anyone who would have seen Morgan downing drinks the whole night like the defense claims, it's their own witness. But remember when I asked her about that on cross-examination? She said, I don't remember seeing that. I don't remember seeing Jessica drink. I don't even know how many drinks she had. Members of the jury, that's their entire case, and their only witness doesn't even know what it means. Members of the jury, she was forced to admit that she never saw any of that. Members of the jury, they asked you those 3 questions. And they want you to think that these questions are key to their case, but members of the jury, we have answers to every single one. First, what did the bartenders actually see? Members of the jury, we know the answer to that. The owner of that defendant bar saw Jessica fall down the stairs. The defendant said, we might need to cut this one off. The defendant said, I hope this one's not driving. Members of the jury, like I just said, the defendant went to their table 10 times. They want you to believe that every single time the defendant went to that table, Jessica just turned off her drunkenness. Second, how much did Miss Marks really have to drink? Here's the jury, we know the answer to this too. There's 1, there's 2, there's 3, there's 4, there's 5, there's 6, there's another shot that's not even on that list. Members of the jury, her BAC, when she drove away from that bar, was at a 0.16. Members of the jury, that's twice the legal limit. The defendant said she had no reason to believe that Jessica was drunk. But look at the evidence. And finally, Mr. Demsky wants you to completely distrust Morgan Levin. Members of the jury, you don't even need to trust her to find the defendant liable. We have video evidence. You saw it. She was obviously intoxicated in that video. How can the defense watch that video and say, nope, I didn't see that? Members of the jury, there was everything to suspect, and Jessica's entire life to save. Find the defendant's bar liable.
Thank you very much, Mr. Castleberry. Mr. Castleberry, Mr. Demsky, fantastic job. Congratulations. I'm going to ask all of our scorers to please submit their ballots. Thank you very much.
Yes, we're good.
Hey, everybody. We have all of the ballots. Thank you very much. I'm going to go work on getting the results in. So can I get our judges on screen to give some feedback and our two advocates? And can we give our advocates a round of applause? Nicely done. You guys were fantastic. I'm I'm going to turn it over to Kyle to lead the comments. We'll keep them brief because these guys are probably exhausted. But one piece of feedback to each one of them, if they advance, one suggestion, or if you want to say your favorite part of trial from each one of them, that's great too. But thank you very much for judging. I hope you enjoyed judging. What a great semifinal round. And we'll be doing the awards announcement at 1:45 in the main Zoom room.
Cool. All right, everyone. So I think we're just going to do one comment per advocate from each of the jurors. I'm happy to lead, and then what I'll do is I'll just go jurors that I see in order on my screen. So Ashley, just word of warning, you're up next. So pressure's on you after this. All right, Mr. Castleberry, I particularly